truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss Chad and Lori Daybell. Well, folks, I'm coming to you today for several reasons. First and foremost, we've been talking about the Chad and Lori Daybell case for over 2 years now. And we've seen this adjudication process slowly turning its wheels. And, I think it was probably about a week ago that I posted on the community wall that Chad Daybell objected to the upcoming pre-trial scheduling conference deadlines. And I put on the community wall that, John Pryor keeps saying, Chad is not ready. Well, the judge denied Chad Daybell's continuance on this January 9th of 2023 deadline of submitting proposals relating to jury questionnaires. John Pryor talked about, we can't go forward with this because we might need someone else to help us, a death penalty qualified attorney and blah, 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 blah. And we got concerned. I did anyway. I'm like, oh, Lord, they're going to push this back even further. But when Judge Boyce denied Chad Daybell's objection to the scheduling deadline of January 9th of 2023, it is clear to me, y'all, just as I said a couple of weeks ago, the judge is going to keep this trial on track. Remember, Lori has not waived her right to a speedy trial like Chad Daybell has. And so he knows, because they're being tried together, that he has to keep this moving forward. Now, I want to break this down for y'all because I'll have to confess, I printed out the pre-trial scheduling conference, the order, talking about the different deadlines until we get to the April 3rd trial. I wanted to go over that briefly, and then we're going to go into some other news. We know that the pre-trial conference for this trial, is February the 27th of 2023. And that's important because there are a lot of deadlines that have to happen. Number one, discovery. All discovery that the state intends to use in the trial against Chad and Lori Daybell has to be turned over before February 27th of next year, right? Of this year. I keep saying next year. It is already 2023, y'all. Can y'all believe it? It's already in January. And by the way, Wayne and I are leaving this Sunday to go to Idaho. We're going to go to Boise. We're going to go to Rexburg. I'm going to do some pre-records. And I'm also going to do my best if Cresha's willing to get with her and maybe do something for difficult research as well. But discovery has to be turned over by February 27th according to law. The judge has laid out this whole thing. He says plea deals have to be in writing, and all this stuff have to be ready to go right before February the 27th. Now, he also says in this pretrial order, he talks about exhibits and witnesses. Okay, now exhibits are the things that are going to be shown. For instance, let's say the duct tape or the garbage bags or the shovel, or those are considered exhibits. Or say, for instance, JJ and Tylee's birth certificates. Those are exhibits. And of course, we know what witnesses are. Those have to be turned over at least 14 days before the trial date, which is April 3rd of 2023. Also, both sides, the state and the defense, has to put together jury instructions, and they all have to go over them, make sure everything is the way they want them. And those jury instructions are very important, especially in a capital case and a death penalty case. Those have to be turned over 14 days before the trial as well. So I've kind of made that clear, but let me just go down this road because it's going to lead into what we're going to talk about today. And that is Idaho Code 18-207. And you might be saying, KJ, what are you talking about here? Well, 90 days, okay? 90 days before the trial, you have to tell the courts that you're going to put up a mental health defense. And so what I want to lead into on that is that Archibald has decided that he is going to turn in, a notice of intent not to raise mental health defense. And you know what that means? Archie is saying that Lori is in her right mind, and as you and I both know, the woman is an evil, diabolical woman. She was faking it as far as I'm concerned, but we're going to look at this document. We're also going to look at the fact that Archibald wants the judge to rule on whether or not the death penalty can be taken off the table for Lori and his reasoning and case law behind that. But before we go into that, I want to make these two definitions very clear to you. We learned something on this channel. What is the principal offender and what is the accessory offender, right? And you're going to understand why I've talked about this. A principal offender in first-degree murder is the one who commits the crime by their own hand. Remember how many times we've discussed it that in Idaho law, if you conspire to murder and you didn't actually do the deed, you didn't actually physically do the deed, it's the same as actually doing it. But it says a principal in first-degree murder is one who commits the crime by their own hand by an inanimate agency or through an innocent party. And this is what Archibald is saying. He's saying Lori is innocent. She didn't actually physically murder J.J., Tylee, and Tammy. Now, an accessory to murder is a criminal offense whereby the perpetrator helps or assists a murderer before or after the commission of the murder. And again, this goes back to conspiracy to commit murder. Lori helped before and she helped after. And so, although we're going to go into these documents right now, Archie is saying that, hey, because I say, this is what Archie says, and he's going to have to prove this shit. He says Lori didn't actually physically kill Tylee, JJ, and Tammy. Okay, put the evidence out there in what? A trial. Don't just assert it, but also understand you've got to prove that. Notice of intent not to raise mental health defense, first and foremost. Archie is saying that Lori has a mental illness, but she is competent, and she's actually trying to help her defense out. Give me a break, y'all. Comes now the attorneys for the defendant, and pursuant to Idaho Code 18-207, he's letting the court know 90 days beforehand, hey, we're not going to say that she was mentally ill. We're not using that as a defense. Give notice of their intent not to raise a mental health defense at the guilt phase portion of the trial. And the guilt phase is the trial itself to find out whether or not Lori is guilty or not. Number one, Idaho Code 18-207 provides that a list of expert witnesses be disclosed at least 90 days prior to trial if the defense intends to call the experts to negate an element of a crime. This advanced disclosure is required for the guilt phase portion of the trial, and the defendant's mental health has been evaluated and litigated since the first filing in this case. She spent 10 months at a mental health facility in Idaho and received mental health care from the experts employed by the state of Idaho Department of Health and Welfare. The defense hired, now listen to this, okay? She spent 10 months in the spa, right? Now, the defense is letting us all know through the court documentation that they hired three independent mental health experts to review and evaluate Lori's mental health. Now, you stop and think about that. Think about the taxpayers of Idaho having to fit the bill for 3 independent experts, and here we are today knowing that the judge has ruled her competent. Due to ongoing mental health concerns while this case has been pending, the court conducted an evidentiary hearing on November the 10th of 2022. Y'all remember that? We didn't see it. We didn't hear it. It was a closed hearing because what? We got HIPAA there. You cannot talk about her mental health. It would have been prejudicial and it would have been against the law for us to hear the audio of it because we know the cameras aren't in there, to determine if she was competent to stand trial. On November the 15th of 2022, the court ruled that she was competent to stand trial. Remember that. And although still suffering, this is Archie talking to us, y'all, talking to the judge. Although still suffering from a mental illness, the defendant is taking an active role. She's taken an active role in her defense. She has previously reviewed all the discovery provided to her by the state and her attorneys. She has consulted with the 3 mental health experts. She does not want to proceed with a mental health defense to negate an element of the crime in this case. She has not authorized her attorneys to proceed with a mental health defense in the guilt phase portion of this trial. Her attorneys are respecting her autonomy and her rights granted to her by the Constitution of the United States. Folks, this woman wants to go down like she does not have this freaking messed up mind of hers. She has got mental illness, but she doesn't want anyone, through her own pride, this is my opinion, through her own pride, she does not want to go down the road that she was mentally ill, and this is why all this happened. But you're going to find out as we move further in this, that this opens the door in these filings to let us know exactly what I think most of us knew anyway. And that is that Lori is blaming Chad and Alex. You'll see what I'm speaking of here. If she is found innocent of the charges, then no such disclosure of expert witnesses will be necessary. If she is convicted by a jury, then the defense will call witnesses, including experts, in support of mitigation during the sentencing hearing. And Archie knows good and damn well, and I can tell you because I'll probably have to talk about it when the state responds to this motion here, that this is her whole mental health and everything, because she is not saying, I was mentally ill and this is part of my defense. First and foremost, we know that's out of her own pride. But second of all, because that is what they're saying now, this will not be a defense. The bottom line is that the state is going to say this was all about mitigation anyway. In other words, when she's found guilty, then you can talk about mitigation. Let me just say it like this. If Archie would have came out in this document and said, we want a mental health defense, the state would have said, well, you can have the mental health defense all you damn well want. But the bottom line is that that's not going to really be part of the guilt phase. It will only be able to be part of the mitigation. And mitigation being that when it comes towards sentencing, then obviously we've talked about it, y'all. Y'all don't want to hear it. I don't want to say it. But because she has been in a mental health facility, the likelihood of her getting the death penalty is slim to none. But Archie's cut this off at the knees, y'all. He's made it very clear that's not the road they're going to go down. And if they're not going to go down this road that Lori was mentally ill and this was her defense, then you know and I know that there is no, it has to be the antagonistic defense. So we look in his further filings where he talks about Lori should not even have the death penalty on the table because she was not the one who actually did the physical killings. Well, he can assert that all he damn well wants, but that's something that needs to be ironed out in a guilt phase of a trial and let the jurors decide whether she physically did it or not. Now, he says in his filing that when he's received all this discovery, there's nothing in it that says that she physically did it. So he's got the discovery that we don't get to see. And he's stating this, so maybe he's right, but maybe he's not. Maybe he's looking at it differently. But let me just open this up a little bit. He says Lori Daybell has been indicted on charges of first-degree murder and conspiracy to commit first-degree murder and grand theft, both of which carry the possibility of the death penalty. And we all know this. But this is what he says. He says, as pled, the defendant does not have the requisite culpability to be charged with the death penalty under the indictment for conspiracy to commit first-degree murder and grand theft, nor as a principal or accessory to first-degree murder. And again, Archie can say whatever the hell he wants to say. That, to me, has got to be ironed out in the trial itself. But then he brings up some cases, and he lays them out and describes them. I'm not going to go into them. What I want to get to is the meat of all this. He talks about another case, right? Then he says, while the Edmond case revolved around a felony murder conviction, the concept is the same for conspiracy to commit murder and grand theft charge, as well as being charged as a principal or accessory in the first-degree murder charges that Mrs. Daybell faces today. It is well established that the death penalty be reserved for the most egregious murders. The court in Edmond rejected the notion that a felon is generally responsible for the lethal actions of his what? His co-felons when it comes to the death penalty. And what does that mean? That means that Edmond, the one he's citing, is there's a whole story behind that, right? I'm not going to go into that. But what I am going to say is he's saying that the Supreme Court said that it's got to be egregious, that if you were there, but you didn't actually physically do it, you're not actually the egregious one. The one who physically did it is the one. So then he goes further into this, and he's talking some more about the cruel and unusual punishment clause of the Eighth Amendment. And we all know that, this was cruel and unusual to do what they did to Tylee and JJ and Tammy. But it says the death penalty is reserved for crimes that are so grievous an affront to humanity that only adequate response may be the penalty of death. The government has pled this case on several alternatives. There's nothing in the discovery of this case that has put Mrs. Daybell at the threshold of killing anyone. This is what he is saying, y'all. And we've seen the indictment, and you don't have to tell everything in an indictment, just what the grand jury brings back and the overt acts. We don't know what's in the discovery, but he's saying there's nothing in there that shows that she physically did this. The two-pronged test of Edmond, and this is the case he's citing, is not met where, number one, the defendant has not killed or attempted to kill, and two, does not have the requisite intent that any of the deaths of Tylee Ryan, J.J. Vallow, or Tammy Daybell should be taken or contemplated, that they would be taken from a plain reading of the indictment. Lori Daybell is not death eligible. He is saying that just because the indictment says what it says, and it does, it comes right out and says she committed murder, she committed conspiracy to murder, and grand theft by deception. The bottom line is that that any of the deaths of Tylee Ryan and J.J. Vallow or Tammy Daybell should be taken or contemplated, that they would be taken from a plain reading of the indictment. Lori Daybell is not eligible for the death penalty. In the case at bar, Ms. Daybell was not a participant in the deaths as a co-conspirator or otherwise, and could not have the foreknowledge that her children, Tylee Ryan and J.J. Vallow or Tammy Daybell, would end up dead. Archibald is saying that Lori did not know that Tylee and JJ and Tammy would end up dead. And I am telling y'all now, this man, he is trying to protect his client, but there is ample evidence, just in the indictment alone, under the overt acts. The fact that this damn whore was the mother of these children, what else did she think when they were not there anymore if she really did not know that they had been murdered? Give me a break. While the state of Idaho may give defendants more rights and more protections than the U.S. Constitution, they cannot give less. Here the state fails to meet the burden that Lori Daybell is eligible for the death penalty under Edmond versus Florida. And here too, the defendant hereby requests that the court issue an order finding that the defendant is not eligible for the death penalty. Y'all, what we know, okay, what we know so far. We're talking about everything that we know. Just what we know. The Chandler dump, the emails, the photographs, the things she said on body cam, the whole 9 yards. The fact that she has been indicted and in the murder of Charles Vallow. This defense attorney is saying that she did not know that Tylee, JJ, and Tammy were going to be murdered beforehand, and she did not know it afterwards. Because here's the bottom line, y'all. The bottom line is if she knew before, then she knew after. If she didn't know before and she knew after, either way, and I think she knew before and after, but I'm just laying it out here for you. There is ample overt acts in the indictment, the discovery that we don't see. The bottom line is this was something that we were concerned with. We were like, who is the state going to say? Because they never do, y'all. In the indictment, they don't spell out Tylee and JJ were murdered in the apartment this exact way, or Tammy was murdered through poison or whatever. They don't spell out the entirety of their case. All they bring up is like transporting body of JJ. They bring up things like that. The discovery, according to Archibald, is that he sees nowhere where Lori could have been the principal or an accessory. And let's look at the principal. Okay, the principal being Lori actually hands-on murdered Tylee and JJ. Okay, and hands-on murdered Tammy. Because in the indictment it says that she actually, well, no, in Tammy's case, she only conspired to murder Tammy. She didn't actually murder Tammy, but conspiracy to commit murder is akin to murder. Does that make sense? And what I'm saying is not only did she get the charge of first-degree murder in J.J. Tylee, but she got conspiracy to commit murder with J.J. Tylee as well. So what I am saying is Archibald says there is no evidence in the discovery that he's received that shows that she physically did this. So this lends one to know that if this is his stand, who else did the physical murders? Is Lori going to say Alex did it, but she had no idea, even though Alex was up her ass 24/7? Or how about she say Chad and Alex did it? and that she had no idea. Is she going to come out and say, well, Chad and Alex, they told me they were taking the kids somewhere safe. I had no idea that they had been murdered. And then when Tammy ended up dying and stuff, no one got arrested. So, I didn't know that she had been murdered. Y'all, this woman can say whatever the hell she wants. She can buck up to her defense team and say, I'm not going for a mental health defense because I'm in my right mind. And by the way, I'm going to help you. I'm going to help you. I have made myself clear, says Lori. I don't want a mental health defense. I'm in my right mind. Even though I spent 10 months in a spa. See, she started out, Mark Means helped her get in there and put all this shit off so she didn't have to face it. But then when she realized it was that they ruled her competent, where was she going to go? Was she going to continue to try to beat her head up against the wall with Judge Boyce about going back to the spa or that she was crazy or whatever? No, she knew that door was shut. She knew also that she didn't want to go in there knowing that she murdered her children and have everyone think she's a nut job. Well, she is a nut job, but I'll tell you this right now, she would have never been able to prove that it was her mental health defense, and that's why she doesn't know. I mean, she could have easily said, yes, I'm going to do a mental health defense, and on top of it all, that mental health defense will let y'all know through these 3 independent psychologists or whatever that I just wasn't in my right mind, and I was seeing things through a tunnel in my mind, and I just believed every word that Chad and Alex said to me. You know what I'm saying? She is on this thing where she wants to say she's in her right mind now. She's helping with her defense. She's made it very clear that she was not the one. She had no idea this was going to happen. And any juror sitting in that jury box is going to say, you were the mother of these children. Well, she could say, well, I thought that Chad and Alex, they took the kids off somewhere safe. I didn't have any idea. I mean, me and Chad rode the bicycles into the storage unit and everything. I thought I was going to get my kids back because their blankets and their albums and stuff. If I thought they were murdered, why even do that? Why didn't I just throw all that stuff in the garbage? Well, she didn't re-up the payment on it, did she? Did she? She knew that shit was going to be thrown away. It was a cover. All those things in that storage unit that she put in there, I have figured it out, y'all. Those were the things that she put throughout her house and set outside her apartment to make people think that those children were still around. That's what that was. That was how diabolical this hussy was. She was the mother of these children. She cannot go back to the spa. She's not going to let anyone think that she is not mentally capable or that any of this happened because she was a nut job. She's going to tell everybody that Chad and Alex did this because she can't just say that Alex did it and that Chad knew nothing about it. And she just can't do that because Alex was with her all the time. So, and she knew every move Alex made. And so she can't say it was just Alex, but she can say it was Alex and Chad. It's the only option she has. Archibald has spelled it out in his motion that she was not the principal offender and that she didn't know that the children had been murdered. And that is big news, y'all. That's something that's confirming anyway, because we knew that Chad was going to try to throw Lori and Alex under the bus. Now Lori is saying that Chad, at least Chad, and she can't just say Alex. If she does just say Alex, then how can she explain that he was with her all the time? And what could Alex have said? And she knew that Alex helped her get rid of Charles Vallow. She knew that Alex helped with the attempt on Brandon's life. She knew all of that. For her to say she had no idea that Tylee and JJ and Tammy were murdered, I could see there being a glimmer of a reasonable doubt because no police ever caught on to that about Tammy for a long time. In fact, we all know nothing was done about that until after the children disappeared, and then they exhumed Tammy. But during the time that happened, if the kids had never been murdered and say Tammy had been murdered and it played out the way it did and she still had the kids, who could have proved it? Because they already said natural causes and there was no pretext of thinking something was wrong through law enforcement if the kids would have still been around. So you could see her saying, I had no idea that Tammy had been murdered because, hey, nobody arrested Chad. There was no investigation on Tammy's murder, or Tammy's death. I could see that, but I cannot see it with her own children. There's no damn way, folks, none whatsoever, that Lori can talk her way out of this and say that Chad Daybell and Alex Cox did this and she had no idea. That's what this paperwork says. This is what the documentation says. Archibald is saying she wasn't the principal. He's even going so far to say she wasn't an accessory before or after the fact. What the hell? What the hell was all the damn lying? What was the lying about? What was the damn fleeing about? What was the damn calling the Social Security office? I mean, do I need to go down a laundry list of everything that Lori Daybell did? And she can explain those things away that, well, the kids were off somewhere. They weren't murdered, I thought. Alex and Chad told me they were fine. Give me a break. So, leave your comments. Let me know what you think. I'm going to be putting together, now listen to me, I'm going to be putting together a pre-record before I leave out on Sunday. I think I'm going to have it out by Saturday over this Bryan Kohberger. We're not going over the case itself. What we're going to do is go through the probable cause affidavit of Bryan Kohberger, the one who murdered. I've looked through the affidavit. He did it. DNA. Let me give you an example. We're going to go over that affidavit, that probable cause affidavit. In it talks about the cast unit. You see what I'm saying? You see where I'm going with this? We're going to take this unrelated case. We're going to apply it to the Chad and Lori Daybell case. Remember this, y'all. If you don't remember anything else, Lori says she didn't know before. She didn't know after. She wasn't the principal. She didn't actually do the deed. She is completely innocent, y'all, according to Lori Daybell. And not only that, Lori also says that she is capable, that she has no mental health defense. What kind of defense is she going to have? I'm looking at you right now, the antagonistic defense, i.e., she's going to throw Chad and Alex under the bus. That's what she's going to do. She's going to act like a stupid blonde, basically. That's what she's going to do, that she did not know. And she's going to try to fill in those blanks and make it sound like, oh, I've got to have an answer for why I told them at the door on the body cam that that JJ was with Melanie Gibb. She's going to have to come up with an answer, just as Jodi Arias went on the stand and tried to explain away. She had all that time to try to make it make sense. But you cannot make sense of someone who's damn guilty as hell. She could have very well been the principal murderer of her own children. Everyone thinks it's Alex. Some of you think it was Chad and Alex and that Lori just let them do it. Well, I'll tell you what, under Idaho law, I think Archibald's forgetting that if you know something about it beforehand and it can be proven during the time that it's done, even if Lori's in the other room and Alex is doing that to the children, the bottom line is, or after, the bottom line is she is deserving of the death penalty. Leave your comments. Let me know what you think. We're going to get back together before Saturday. I love you all. Keep on looking.